Hello everyone. In this video I'm going to be going over the Unit 3 concept map that I assigned to you today. This was a core component of your Unit 3 exam review, and so I'm going to go ahead and walk you through how I would approach this in the hopes that it also inspires you to review some of this material and gives you some insights into some of the key terms that you need to know to master the exam tomorrow. I do think that if you know the majority of these terms, well actually some of these terms are not relevant to this exam. So for example, Bostock versus Clayton County, some of you will get to read excerpts of that opinion on Friday. Shelby County versus Holder, US versus VMI. That's just some of the extra stuff that I'm doing as a wonderful government teacher, trying to keep you guys up to date about some important Supreme Court rulings, Shelby and Bostock, and Obergefell, which is not listed on here, that will potentially appear on the AP government exam, but are not required Supreme Court cases. But the rest of the terms, if you know them generally, you should score pretty well. If you know them, you know very detailed, or you know, for example, if it's a Supreme Court case, if you know the facts behind the Supreme Court case, the general facts, the constitutional clause associated with that Supreme Court case, because Supreme Court cases, we care about them in Unit 3 because they provide insight into the scope of those rights, either in the Bill of Rights or in additional provisions of the Constitution, stuff like that. You know the holding of that Supreme Court case and the significance of that Supreme Court case. You're on track for a 5. So I'm going to start with the 14th Amendment. I've talked to you about the 14th Amendment a lot of times. We can see right here, Cassie drew a wonderful anchor chart for me up on the 14th Amendment, where she wrote out Section 1 of the 14th Amendment, and she listed some of the key provisions of the 14th Amendment. Right? The core two elements being the due process clause of the Constitution and the equal protection of the laws. In fact, I'm going to scoot this over, and this is where I'm going to draw my concept map right next to the 14th Amendment, because the 14th Amendment is so important. And so the 14th Amendment is right here, and then another one of my terms is selective incorporation. And so this is the approach that the Supreme Court uses to essentially incorporate or apply the Bill of Rights, because remember the Bill of Rights is originally restrictions that are placed on the federal government to the states as well. Right? So the court applies the Bill of Rights through this doctrine called selective incorporation. It's called selective incorporation because the court does it bit by bit instead of applying the Bill of Rights all at once. And there's still elements of the Bill of Rights that have not been selectively incorporated. Okay, so selective incorporation goes here. I'm also going to connect the 14th Amendment to the 13th Amendment as well. Right, this is the one that abolishes slavery, and we watched the documentary 13th, and the 15th Amendment as well. Right, I put the 14th in the center because to me it is such an important amendment, not only because it provides citizenship to formerly enslaved people, but it also articulates these very important principles, says that citizens have certain privileges and immunities. Unfortunately, the Supreme Court interpretations in the the late 19th century actually eliminates that as a tool to expand rights and privileges. But the due process clause, you can't deny anybody life, liberty, or property without due process of law, and you can't deny anybody, or a state can't deny anybody the equal protection of the laws. Those are important principles that play an important role in constitutional law and obviously our society. So, the 14th Amendment, the 15th Amendment provides suffrage. It says that you can't deny someone suffrage on account of race. Again, we are familiar with the Galley-Walk that we had, but the 15th Amendment is narrowly interpreted by the Supreme Court and a very cynical attempt by states to get around the 15th Amendment through poll taxes, literacy tests, and actually, straight up open terrorism. Essentially, denies African Americans the right to vote for several years until the passage of the 1965 Voting Rights Act. So I'm going to link the 15th Amendment to the 1965 Voting Rights Act, which does several things. One of the key things that it does, which we'll talk a lot about on Friday, is that it required, at least for some time until the 2013 Shelby County versus Holder decision, it required former Confederate states states with a history of discriminatory voting practices to go to the federal government and seek preclearance before they change their laws, right? So this was an attempt to prevent these states from trying to find innovative new ways to discriminate and deny African American groups or certain classes of people the right to vote. It also banned literacy tests. The 15th Amendment, I might also link it with the 24th Amendment because the 24th Amendment actually bans poll taxes, which is a super important phenomenon. And I might also link it with the Voting Rights Amendment because it's doing, pretty important work. All right, so I'm linking these terms. In my mind, I know how these ideas relate. I might also link Brown versus Board of Education to the 14th Amendment. We talked about in 1954, the Supreme Court, the Warren Court, overturns the judicial precedent set by Plessy versus Ferguson. Remember, unfortunately, the Supreme Court was presented with this case in 1896 to determine whether racial segregation is constitutional or not, specifically whether it violates the Equal Protection Clause of the Constitution. And the Supreme Court says, infamously, that as long as the facilities were separate but equal, it doesn't violate the Equal Protection Clause. Right, this was a very horrible decision, or very disgusting judicial opinion. It's finally overturned in 1954 by the Warren Court's opinion in Brown versus Board of Education, that judicial precedent. So I might even link the doctrine of stare decisis to Brown versus Board of Education because we can see Brown versus Board of Education overturns that previous Supreme Court precedent, right? So it violates the principle of stare decisis, of letting the decision stand, which is a good thing, right? But we have to know this term. Let's see, what other terms could I link? 13th Amendment, I put in there mass incarceration, which is kind of like more into current events. We watched that documentary 13th, and that documentary 13th, we watched it. I mean, it provides a lot of interesting updates about certain things that are happening in politics and government today. But we watched the documentary 13th, and we read The New Reconstruction, which is this awesome article by Adam Sewer out of The Atlantic. And we did a gallery walk trying to look at the pieces of evidence look at a lot of pieces of evidence that Sewer weaves into his essay to essentially as sort of like a learning tool, right? To help us kind of keep track of like these key ideas and connect the dots and kind of build a story to them. Also, the documentary 13th really kind of links together mass incarceration, right, which is an issue that is in the United States today. It's this idea that the United States is 5% of the world's population, but has 25% of the world's prisoners, to the 13th Amendment, right? Specifically the abolishment of slavery in the 13th Amendment, and there's this sort of loophole, as the documentary presents it, that says that you can be denied rights and liberties if you're, a convicted felon. The 14th Amendment, this doctrine of selective incorporation, I might link it to the other amendments that I have on the list, like the 6th Amendment, because I know the Gideon versus Wainwright decision, although we talked about it within the context of our discussion about the 6th Amendment and the right to counsel, the right to a lawyer, we did not, it's also related to selective incorporation because the Gideon decision was fundamentally, it incorporated, through the due process clause of the 14th Amendment, the court incorporated through the due process clause of the 14th Amendment, the 6th Amendment to apply to states as well. So in Gideon versus Wainwright, remember that the holding was that Gideon was in fact entitled to a lawyer even though he could not afford one, right? Was a radical position at the time, and the court said that it was a core element, an important element of due process of law, right? You are entitled to a lawyer even if you cannot afford one. We also, just besides the point, we watched a video about how underfunded public defenders are, and we kind of thought about, some of the limitations, right? This is an important right. A lot of you thought this was an important right to be entitled to a lawyer if you cannot afford one. However, there were limitations to it. We also talked about the 5th Amendment, and we talked about the Supreme Court case Miranda versus Arizona, and we said the 5th Amendment specifically, we talked about self-incrimination, and Miranda versus Arizona, remember, it was that Supreme Court case that said that ignorance of the Constitution, that a person that incriminated themselves without knowing their rights, that was a potential procedural flaw, not informing them of their rights, and that police needed to start informing people when making arrests of their rights, right? And so we get the Miranda rights, you have the right to remain silent, anything you say can and will be used against you in the court of law, so on and so forth. We also, through this doctrine of selective incorporation, right, we can really link up all these amendments because our cases are fundamentally cases, we studied them as cases of like the First Amendment or the Second Amendment, but most of them are essentially cases related to, are also selective incorporation cases where the court selectively incorporates elements of these amendments and applies them to the states as well. So the First Amendment cases that we studied, there was a variety of First Amendment cases that we studied. So specifically we studied Wisconsin versus Yoder, which dealt with freedom of religion. Remember, is that Amish school parents that didn't want to send their kids to school, even though there's a mandatory education law, and the Supreme Court was exercising judicial review to determine whether that mandatory education law violated the free exercise clause of the Constitution. Right, the free exercise idea being that the government can't prevent you from exercising your religion. Right, of course, there are limitations to these rights, and so the Supreme Court's interpretation and the limits that it sets are important. The Supreme Court held in Wisconsin versus Yoder that that mandatory education law was violative of the First Amendment's free exercise clause. Then the other clause related to religion in the Constitution is the Establishment Clause, this idea that you can't establish an official religion, that the government can't promote one religion above the other. It's related to the First Amendment to the Constitution, and then we can draw a link to Engel versus Vitale, which banned mandatory school prayer. Right, we also saw Sally Yates. A lot of you still talk about Sally Yates quite a bit. The reason why she chose not to send lawyers to defend President Trump's executive order, which critics called the Muslim ban, was because she felt it was violative of the Establishment Clause of the Constitution. And we saw in her exchange with Ted Cruz, she talks about the Establishment Clause. She also talks about the Due Process Clause and the Equal Protection Clause. Oh my gosh, you guys are becoming lawyers. Continue. We can also think about the 14th Amendment's Due Process Clause, right? We connect due process. I mean, that's the mechanism by which the court seeks to apply the 14th Amendment. I'm sorry, it seeks to apply the Bill of Rights to the 14th, or to the states as well. Think about the Due Process Clause, and we can connect it to substantive due process. And we said that there are basically two types of due process. The more controversial one is substantive due process. The less controversial one is procedural due process, which is this idea that there should be common standards when we're depriving persons of life and liberty or property, because otherwise government is just arbitrary and can be, bad government. But substantive due process is this idea that there are certain substantive rights, fundamental rights and liberties that are so fundamental to what it means to be human, no matter how much process is given, they can never be taken away. So some people say that this substantive due process clause can lead to judicial activism because it allows, according to critics, judges to subjectively say or categorize rights or liberties as, substantive and essentially legislate from the bench, and then say that legislatures, either state legislatures or the Congress can't, deny or legislate on these rights or liberties. And so there are some famous cases related to substantive due process that use the substantive due process, So one of them is Obergefell versus Hodges, which we'll talk about on Friday, which legalizes same-sex marriage, and the other is Roe v. Wade, right, which says that there's a constitutional right to abortion, right? It kind of says that, it's a very private decision, deciding to terminate a pregnancy between a doctor and a mother, and there should be a constitutional right to abortion within the first trimester. Also foundational to the Roe v. Wade decision was the Supreme Court precedent of Griswold versus Connecticut, which said that a Connecticut law banning contraceptions was unconstitutional. And remember, this was the Penumbra decision where the Supreme Court said there's nothing about privacy within the Constitution, but they took the First Amendment, they took the Third Amendment, which prohibited the government from quartering troops in your house during times of war. They took the Ninth Amendment, which said there were other rights and liberties that are not, enumerated within the Constitution or the Bill of Rights, and they took the 14th Amendment and they